yes, when the Supreme Court decided Sweat versus Painter, that was a Texas law school case. See, Sweat had filed a suit because he had applied for admission to law school. Well, they wouldn't let him in the regular Texas law school, but they opened up one storefront law school. Had one teacher and a few books, and called it a law school. And so we filed. The NWC filed a suit, and the case went to the Supreme Court. And the Supreme Court we had worked on a brief setting out all the things that would constitute a first-class law school that was available at the University of Texas Law School. And Judge Vincent went right down the line of our brief. So we figured now we got Vincent on our side and he understands what the problem is. Now it's time for us to go ahead and file challenge segregation per se. And that's what we did. And so what the first case was Bree versus Elliott down in Columbia, not necessarily Columbia, down in South Carolina, Clarendon County, South Carolina. And that case went up. The suit, Thurgood filed the suit, and we were all spotting out counsel in the case, and Robert Twatter and a guy named Bullock from down Columbia, South Carolina, and when they filed the suit, Judge Warren recognized the fact that they were testing the constitutionality of state law, and he convened a 3-judge court. And anyway, the 3-judge court ruled 2-1 that no violation of law. That case was appealed to the Supreme Court. It was the first case up there. All right. When these kids went out on strike, that was the only case, that case going up to the Supreme Court.
These were the kids in the Prince Edward County Public
Prince
School?
Edward County.
Yes.
Barbara John, the leadership of a very precocious little girl named Barbara Johns, who was the niece of a fiery Baptist minister named Vernon Johns.
Oh, yes, another legend.
Yeah.
Yes.
And so when they went on strike, Martin and I were in our law library that evening when the phone rang, preparing a motion for further relief in a case known as Corbin versus Pulaski. It was a separate but equal case because they had all the children up in that section of up around VPI, that section of Virginia, were Paul Hall from Pulaski about 50 or 75 miles through Radford and over to Montgomery County and Christiansburg. There had formerly been a little private school over there, a man named Long, who left there and went to Howard. Very fine man. And anyway, so we had a trial, and they had done what they're supposed to do. We carried the case to Fourth Circuit, and they Fourth Circuit ruled with us, and so we found a motion for further relief, and so the phone rang. I happened to be the nearest one to the phone, and I picked it up, and I heard Barbara Johns tell me what they'd been out on the strike and what they did and all that. And they wanted us to represent them. I said, well, what you all do? We've already filed one suit challenging segregation. We don't need but one to prove the point. And y'all going back to school now.
And this was in a rural area too, wasn't it? Prince
Oh, yeah.
Edward, yes.
Yeah, and so, but she pleaded so hard. So I said, well, listen, we be coming through for Farmville on our way to Christiansburg on Wednesday. We'll leave a little early and meet you in Reverend Griffin's. Of course, we were familiar with the situation because I'd been down there several times to talk to the school board. They were still claiming they're trying to get money to build another school. See, that school, when it opened up in 1939, it was overcrowded the day it opened. So how much planning went into it.
Of course.
And they put up these tar shacks and run pipes running from one school to another, and all big oil drums to provide the heat. And then when it's raining or inclement weather, kids were going to be one building and in the mud and whatnot, going to these other classes in these other buildings. It was a health hazard.
Yes.
So anyway, so that on our way up there, we still made up our mind that we were going to tell the kids going back to school. But when we got there, they were sitting up in the school, Sunday school room of Reverend Griffin's church, and it was so orderly and had such high morale that moral. Anyway, it had hard to some say no, so which I told them, I said, if your parents will back you, we're not filing them more separate but equal. If your parents will back you, we'll file the suit, and we'll on your behalf. And now we're going up to Christiansburg today, we'll be up there tonight, and we'll be coming back through here tomorrow night, and you can meet us here with your parents. So that's what they did, and the parents were there, and the parents was willing to go back to children. But somebody said, well, look, this is a county affair. Look like we ought to take this up with the whole county. So this was Thursday night, this week, 1 week. We set a meeting for Friday night of the following week. And we got, Spot and I got over Friday night. We had the meeting in the church proper, and the place was packed. People standing around, even at all the hours and everything.
So you knew they were serious.
Yeah.
Yes.
So there was only very little opposition. The main opposition was from the principal of Cumberland County High School, who lived in Prince Edward County, and we understood his problem. If he'd been for it, they would have fired him in Cumberland County. But anyway, the county voted to back the suit, and so we filed a petition, and that was denied, and saying that they talked about they were going to get money in 2 years from the state and a whole lot of crap. Anyway, we went on and filed the suit, and meantime, they tried, the day of the trial down in South Carolina, something happened and I couldn't go, but Spot went down, and as I say, they appealed to the Supreme Court. All right.
You're talking about Spotswood Robinson?
Spotswood Robinson.
Yes.
Yeah. And but some, I've forgotten what the technicality was, some technicality, and they sent the case back to South Carolina for something, and clarify. And meantime, all the rest of the case, our case, the Delaware case, Kansas case, all went up to the Supreme, and the District of Columbia case, all got to the Supreme Court. By the time the South Carolina case got back up there, all 5 of the cases were up there. I mean, the other 4 cases were up there. And either, I suspect that the problem was, whoever consolidated them didn't realize that I came before O, and so they had Brown rather than Briggs. That's what it should have been.
Yes.
And on top of that, just like we we should, our case, we named Davis, because we put them, both kids in alphabetically, and we should have, case should have been styled Barbara Johns, because
Yes.
she was a more motivating force there. Anyway,
So all of those cases were consolidated.
all of them consolidated at Taylor Brown. Now, the three cases, the Kansas case, the Virginia case, and the Scranton County, South Carolina case, were all similar in that it was three cases where the plaintiffs were applying, asking that the Plessy versus Ferguson be overruled. The Delaware case, the judge had overruled Plessy, and the school board was appealing. So it was a reverse situation in the Delaware case, where Greensburg and Redding were attorneys, and in District of Columbia case, District of Columbia was not a state, so the 14th Amendment didn't apply to District of Columbia. They filed under due process.